Welcome Ignacio. Thank you so much for joining us here at UNV Law. We're sitting in the lab room of the Legal Innovation Laboratory, and we have with us Professor Cofone, incoming professor at the University of Oxford, focusing on law and the regulation of AI.
Yeah, thank you so much for having me here. I'm very happy to be here to speak with you.
Fantastic. Thanks for joining us. You're joining a larger symposium, workshops on access to justice and technology. It's a new Brunswick Access to Justice, a series of workshops. And we have the honor to listen from you, from the author, from the expert, about whether the privacy framework of Canada, of our times, are ready to take on the challenge of AI in the courts and outside of courts. You recently published your book, your most recent book, The Privacy Fallacy, with Cambridge University Press. Could you tell us a little bit about this work and your research in particular?
Yeah, the book is about, as you were saying, how privacy and data protection law frameworks need to adjust to cope with new forms of data processing, and in particular AI data processing. Much of it is about privacy law's focus on individuals, on protecting individuals, and mostly on letting individuals protect themselves, which used to work 30 to 40 years ago, when most data interactions between companies and individuals were one-to-one interactions about very specific types of information where people had real choices. But today, we don't have meaningful choices over information. AI processing unlocked a host of inferences about us over which we have no control, and it's impossible to give us control. They are actually way more risky than the piece of information that we disclose. And data becomes more and more interrelated, where many times people have consequences, not even about inference created by the data that they disclosed, but inference about them created by data that others disclosed. And in that context, we need to move away from individual consent and individual control mechanisms to collective accountability mechanisms, because that would mean that people would actually be protected for the data practice that we have now.
That's great. That sounds great, and it really sounds like it's the next step forward for the reforms in privacy laws. You've been involved, and you know a lot about the reform talks in Canada. Are you optimistic about where these discussions are going from your perspective so far? Obviously, I don't ask you to predict the future. We don't have a little ball.
I have moderated optimism. I think many of the new statutes that we see now popping up in all parts of the world, including Canada, both at the federal and the provincial level, do repeat some of the mistakes that we've been making. Mostly the mistake of having so much focus on individual control over personal information. But at the same time, we do see acts coming up, mostly acts that are focused on AI, that seem to be aware that it is impossible for individuals to protect themselves against AI. So we cannot just give them choice about what process to be under and what process not to be under and just call it a day. And so they do at least attempt, at least at the broad level, to produce these frameworks of transparency, fairness, of accountability. And as we continue using AI processes in more aspects of our daily lives, both socially and economically, and these statutes continue to pop up in other places and they become regulated and specified, I hope that that will filter also into privacy and data protection law, because these two fields of law already exist together and continue to blend together. So what we learn in one of them, I think, will inevitably, or at least that's my part of optimism, move to the other one.
Yeah, absolutely. And do you have any specific advice for public institutions, specifically courts, where downstairs we're in a room together full of justices, and you've seen the anticipation and the anxiety around it. Is it something that you think requires particular attention, or are we just we need to figure this out at large for multiple fronts, private sector and public sector together?
If I were to have one piece of advice, trying to have that cover the public and the private sector, I would say when you're regulating or adjudicating over AI, don't focus on regulating a technology. Focus on regulating the social and economic relationships that are intermediated by the technology. We don't care so much at a regulatory stage about the specifics of how an algorithm works, beyond the fact that they may produce injustice, they may produce discrimination. And if we focus on those shifting social and economic relationships, as opposed to focusing on the specifics of a particular technology, that will lead to a richer discussion that pays attention to who wins and who loses in different interactions, how power shifts, and also that leads to regulatory and adjudicatory principles that last for longer, even when the technology changes.
Wonderful. Thank you for sharing this valuable piece of advice, and thank you again for sitting with us and for coming.
Thank you for having me.
And we'll talk about all these things more as developments are ahead of us.
That's good. Thank you.